Thank you, Mr. Chairman. First of all, I'd like to thank you and the committee for allowing us this hearing on the bill. We appreciate it. Thank you so much. And I certainly would, you'll have to applaud, but I want to tell all of you, thank you so much. I appreciate you being here. It's a sacrifice for you to be here. And I understand that, and I just appreciate you so much. Thank you very much. So thanks to everybody. Okay? Mr. Chairman, this bill H3101 is a bill to pretty much stop ObamaCare in the state of South Carolina. And what we want to do with this bill, first of all, what this bill is not about hate or of anybody or any administration or anything like this. This is a bill about love, and it's a bill about love of freedom, love of liberty, love of our way of life. And it's also, this bill is particularly about my children and my grandchildren and all these people's children and grandchildren that's going to be coming out. They deserve to have the opportunity to live in a country that I grew up in. And what I firmly believe is this bill is going to impact that dramatically. Just a quick history. We've got some good speakers following me, and what I'll do is I'm going to tell you just quickly a couple of brief statement about this, and then I'll leave it to the speakers. And they should answer just about any question I think you'll have. And if they don't, at the end, if you want me to come back, I'll be glad to answer any questions then. But what this is an issue where we put together a committee of people, volunteers, medical doctors, attorneys, small business owners, pastors. Back in September, we started meeting to look at this. My constituents wanted us to do something about stopping this bill. And I totally agreed with them, and I wanted to do something about it. So we put people together. We took a look at it. We did our homework. We studied this. We had constitutional people, scholars that we talked with on the phone. I'm working with 7 other states on this now, 7 other legislatures and senates of other states that are in various parts of this and various impacts of this. So I have talked with all of them. We feel like it's the thing to do. We feel like we're doing something that's legally, morally, ethically correct. We believe we're okay on that. If we didn't, I wouldn't be doing this. And I believe passionately about what we're doing. So this bill is about stopping Obamacare in the state of South Carolina, and it's for the good of the people. There's issues in here that clearly seem unconstitutional, and there's some that are just plain wrong. Now, we can't do too much about the wrong thing of our feelings and all, but we could do a lot about being unconstitutional. 10th Amendment Center has worked with us a little bit. There's several other people who have looked at this, and I believe in what they're doing. And so, with that being said, that's what this is about. And the people, my constituents, I am duty bound as a legislator to do what I feel like my constituents want within the law. And it's an honor and a privilege to do this, and I don't take it lightly. It's a pleasure to do it. So, but other than that, it's our duty. And I think as a state legislature, that we have a chance to stop this now, and I think we'll have other states to follow us. So I'll yield the rest of my time to anybody else that wants to speak like this, and if you need me to come back, I'll be more than happy to.
Thank you, Representative Chumley. Representative,
Excuse me, thank you, Mr. Chairman. Representative Chumley, I have a few questions for you. I have some questions about your bill.
Representative Chumley, you want to take questions now? All right, Representative.
I'd like to address them to you, though, so you'll still be here later.
All right, the next, we have Professor Crocker. Professor Crocker, thank you for being here. Come up and introduce yourself. Tell us who you are.
Hi, I'm Professor Thomas Crocker. I teach at the University of South Carolina School of Law. I teach constitutional law.
Okay, thank you for being here.
Thank you for having me. Would you like me to just?
I would. Just,
all right. So let me thank you, Mr. Chairman, for having me to speak here, and thanks to the rest of the committee for having me to speak here. Sometimes lawyers and constitutional lawyers are no different. Speak with two hands. On the one hand, on the other hand, there always seems to be two answers to a constitutional law question. But this is one of those rare occasions in which there's a one-hand answer. This is one of those clear occasions in which the proposed bill is unconstitutional. There's one and only one right answer to the question of whether it is in fact constitutional. The state of South Carolina lacks the power to nullify a duly enacted bill by Congress. So let me provide you just a little bit of legal background. The Patient Protection and Affordable Care Act was passed by the U.S. House of Representatives by a vote of 219 to 212, and in the U.S. Senate by a vote of 60 to 39. It was then presented to the President, who then duly signed the bill into law, in accordance with the bicameralism and presentment clause of Article 1, Section 6, Paragraph 2 of the U.S. Constitution. On completion of this procedure, the Affordable Care Act became the supreme law of the land, pursuant to the U.S. Constitution's Article 6, which provides, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land." The Affordable Care Act was challenged in federal court under various theories that the act was beyond the power of the Congress to enact. On June 28, 2012, the U.S. Supreme Court ruled on those arguments in a case called National Federation of Independent Businesses versus Civilians, holding that the basic provisions of the act were Constitution under Congress's Article 1 power to levy taxes. Since the 1803 ruling in Marbury versus Madison, it has been well established that under our Constitution, the Supreme Court has the ultimate power to decide matters of statutory and constitutional interpretation. And if there were any doubt about the matter, in a case in 1958 where the governor of Arkansas had attempted to defy a desegregation order, the Supreme Court held that Marbury, quote, declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution, end quote. To underscore its claim in Cooper v. Aaron, each of the 9 justices individually signed the opinion, the only time the court has ever done that. So, underscoring the idea that the federal judiciary is supreme in the exposition of the law of the Constitution. So to recap where we are regarding the Affordable Care Act, we have a law duly passed and signed under Article 1's bicameralism and presentment clause, a final authoritative interpretation rendered by the U.S. Supreme Court holding that the act was within the power of Congress, and we have Article 6's declaration that federal law shall be supreme in the law in the land. With that, South Carolina lacks any power to render the Affordable Care Act inoperative in the state of South Carolina. As a general matter, we can turn to the Supreme Court's 1819 opinion in McCullough v. Maryland, where Chief Justice John Marshall made clear, quote, "Whatever the United States have a right to do, the individual states have no right to undo." This is the baseline, uncontestable conclusion of constitutional law. South Carolina lacks the power to nullify a federal law. Article 6 of the U.S. Constitution makes clear, again, that this Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. This is the Supremacy Clause. Now, if I'd like to go through a few of the provisions of the Act, also suggest a few additional issues of constitutional law that the Act runs up against. First, in the preamble, there are 2 problems in the preamble. One is a little more philosophical problem with the preamble's presentation of the power of the states vis-a-vis the federal power. In the 1819 Supreme Court case to which I've already referred, McCullough v. Maryland, it has been the law of the United States that the power of the United States government derives from the people, not from the states, and not from the people of the several states. In an 1816 case, Martin v. Hunter's Lessee, again, Chief Justice John Marshall writes, "The Constitution of the United States was ordained and established not by the states in their sovereign capacities, but emphatically, as the preamble of the Constitution declares, by the people of the United States." There can be no doubt that it was confident to the people to invest the general government with all powers which they may deem proper and necessary, and give them a paramount and supreme authority. This is what we did as a country. We gave the federal government supreme authority to act within its